Good morning. I'll open this Committee on Commerce being 9 o'clock. And we've got 5 bills today. We'll be starting off with Senate Bill 207, which I will introduce.
Senate Commerce Committee is proud to welcome Senator Harold French to introduce the next bill. Go ahead, Senator.
Thank you, Mr. Chair. Good morning, committee members. It's a glorious day. The snow is gone. The sun is shining. My name's Harold French, Senator District 7. And today I'm introducing Senate Bill 207 at the request of the Insurance Department to clarify that a company's cost of retaining an outside expert for review of their annual statements will be credited towards their assessed administrative fees for the subsequent year only. The current language suggests such credit may be carried over into future fiscal years, but since this credit pertains to an annual review cost, the practice is to apply it only to the subsequent year. Any future credit earned for costs associated with future annual reviews will likewise be applied only to the year subsequent to the year such credit is earned. Therefore, if you took statistics like I did, you'll understand that completely. The insurance industry is fine with this clarifying change, and Doug Bartlett is here from the Insurance Department to answer any of your questions that I cannot. Thank you very much.
Thank you, Senator French. Does anyone have any questions for Senator French? Thank you, Senator.
Wish I could think of something.
Doug, would you come up? Thank you.
Good morning, members of the Senate Commerce Committee. My name is Doug Bartlett. I'm the Director of Financial Regulations for the Insurance Department. Just to add what Senator French said, this section of the law was enacted to be able to contract for analysis assistance if needed. The consultants would be paid by the insurance companies that they assisted to help the department with its analysis. Those insurance companies would be able to offset their payments to these consultants with a credit to the administrative assessment. The administrative assessment is the assessment that the insurance companies pay to cover the cost of the insurance department. The total amount of the assessment is not lowered by this credit. It's added back in before we calculate the credit, so that the amount that the insurance department gets is going to be the same whether there's a credit or not. The original law said that any amount not used in the first year could be carried over until it was completely earned. That didn't work. And a lot of these companies that are licensed don't write much or don't write anything at all. They're surplus lines company, and that could take 25 years to keep track of, and the amounts are pretty much de minimis to these large companies. Since this is an annual review, we want to make the credit apply only to the subsequent year. And I can answer any questions you might have.
Thank you. Any questions from the committee? Seeing none, thank you very much.
Thank you.
Marty Mobley is signed in support, not wishing to speak. Chris Nikopoulos supports, not wishing to speak. George Russo supports, not interested in speaking. Anyone else here for this matter wishing to speak? Seeing none, I'll close the hearing on Senate Bill 207. There. One down.
You want to wait till he's done?
Let's do it. That's what I was thinking. Yeah. I've got to go next door for introducing a lobster pot bill. So, so my trusty assistant, vice chair, will be taking over next.
So you're gonna take that with you to crack the claws?
Yeah.
You got some silver. Thank you. What time is it, anyone say?
It's gonna be a two.
No, I know that.
You got,
I'm
it's
in.
9:06.
9:06. Tell me when it's 9:15. All right, wake me up. Go have some fun. Lobster pots.
Hey, we started about this. Good.
We exact a few, but that's okay.
Did you?
Yep. No questions.
Quick. Senator French, got all the details ironed out.
Administrative fees, they get to.
Thank you.
It
Yep.
doesn't matter. Not a big.
Oh, I thought that was in here.
Marty did a great job. Thank you.
It's what? It is a lot, isn't it? Yeah. Oh, good. Oh, good for you. So we're having Curie. So I dropped him off at the airport today. Sorry.
It's really hard.
Yeah.
That's what I said to you. I said, this work, it has to be confident, so. Last night. Yeah.
This is good though, or bad.
During the day, but they usually. So they do, you know, electronic. So you sit at the table, she's on a screen, and it's always a woman, and you play, and then it's like.
Chairman and Commerce Committee. My name is Kevin Cavanaugh. I represent District 16, Bow, Candia, Dunbarton, Hooksett, and Manchester Wards 1, 2, and 12. I am introducing Senate Bill 208 at the request of the Insurance Department to update and modernize RSA 408, which regulates life insurance. This rewrite project has been ongoing for a couple of years. In 2020, the department requested Senate Bill 664 that stripped out the outdated and obsolete provisions of RSA 408. That bill passed the Senate on a voice vote, but was then tabled in the House once the pandemic hit. The language proposed in Senate Bill 208 not only strips out the old provisions, but also revises the remaining provisions to bring them up to date, resulting in a proposal to repeal and reenact RSA 408. The department provided a legend to the committee members that references the proposed changes section by section, and Commissioner Nicolopoulos with the Insurance Department will come up to walk us through the bill and answer any questions you may have. Thank you, Mr. Chairman.
Thank you, Senator. Does anyone have any questions? No? Even if John has none.
Thank you.
Senator, it's Nicolopoulos. Good morning, members of the Senate Commerce Committee. Thank you for the opportunity to speak. My name is Chris Nicolopoulos. I was honored to have this bill introduced by my own senator, and he did a very good job of outlining why we're here on this bill. This is a multi-year process by the department to modernize RSA 408. It's important to understand that much of 408 dates back to 1850. It was appropriate to bring those definitions and references to modern times. We've worked with all the constituencies that will be involved in this, and I suspect you'll have unanimous support. You do have the track changes or the legend. I'm happy to answer any questions, but I ask for your support of the bill.
Thank you. Anyone have any questions? No, thank you very much. Marty Mobley supports the bill, does not wish to speak, and that is it. Okay. We will end Senate Bill 208. What's that?
I hope they both make it back.
Yes. It would be kind of good.
I mean, these are pretty straight.
They are, but I wonder what the lobster pot bill's about.
I know.
All senators shall get a small stipend of lobsters. Hello.
Can you hear me? You still can't hear that, Nancy? Okay.
We got 6 inches, you know, plenty. Yeah, it was wicked heavy. I'll open the hearing on Senate Bill 331 with the prime sponsor, Senator Susi.
Thank you, Mr. Chairman, members of the committee. For the record, I'm Donna Susi, representing Senate District 18, Manchester's Wards 5 through 9 in the town of Litchfield. I bring to you Senate Bill 331, which is a bill I introduced on behalf of one of my clients, Mark Jenkins, who's going to testify. Essentially, New Hampshire is unique in that we do not require insurance for automobile drivers, unlike some of our other states. So we've created a system whereby there is a collection process and a different way of dealing with uninsured motorists. Where the problem comes in is when the victim of an accident where there is a known perpetrator who causes it is charged for the accident until all of the monies are recouped. So essentially, someone has to upfront the deductible in order to get their vehicle repaired. And in many times, this creates a very onerous burden on the individual in those circumstances. And this effort to try to address it, I think is an important one and something we need to take a little time to look at. With that, I'd be happy to answer questions, but I would defer most of them specifically to my constituent, Mr. Jenkins, who can give you a lot of real-world examples where this has occurred.
Great, thank you, Senator. Any questions? Seeing none, thank you very much.
Thank you, Mr. Chairman.
And we have James Fox from the Insurance Department, opposed and speaking.
Good morning. My name is James Fox, and this is Emily Doherty, also from the Insurance Department. I'm the Property Casualty Director. She's the Property Casualty Attorney. We usually work together on most of the stuff.
Good morning.
When the department looked at this bill, this is what we call the collision deductible waiver, is what it's generally called. And it was put in place primarily, if not only, because New Hampshire is not a mandatory insurance state. So the idea, all of our laws for uninsured motorists and then this collision deductible waiver is that you're able to protect yourself. So you get your insurance and then you're protected. That's a system. Whereas in a mandatory insurance state, the idea is the other person is supposed to always have the insurance, so you don't have to worry about yourself as much. So it's got 3 prongs, this law. So you get into a car accident. A, it's with an uninsured motorist. B, you know who the uninsured motorist is. So it can't be like a phantom vehicle. And then the third one is the uninsured motorist is solely at fault. And so in that case, because the usual system of subrogation against an uninsured motorist might be more difficult because they don't have insurance and they have what sometimes be only their own money, and if they don't have a lot of reasons, sometimes they don't have insurance, maybe because they don't have a lot of money. So in order to be able to protect yourself, the legislature put in place this collision deductible waiver, so the deductible you have to pay to have your car fixed and the collision way is, so first party, is waived. So it's an actual waiver, is how we look at it. And that way you're able to protect yourself and you're not against an uninsured motorist and you're not penalized. So it makes the not requiring insurance work well. So now the change that's being proposed is to move this to take out the uninsured motorist. So now you don't have an uninsured motorist. Now it's just if you get into an accident with somebody with insurance, then so that they have insurance, then they're ID'd and they're solely at fault, then again, you'll be, the insurance company would be required to waive your deductible. Now, the insurance department is opposed to this because New Hampshire works in this context like any other state. There's liability coverage on the other side, so you can then have a choice as the person who's injured, as the victim. You can either go into the other party's liability coverage, or you can go into your own collision. It's really your choice. Now, if you go under your collision coverage, then what happens is called subrogation. So your insurance company will contact the tortfeasor's insurance company, and then they will work on getting the money basically back from them for the deductible, and then your deductible is covered. But it's not a waiver. Now this is a system that's worked across the country. And just to go back, the 412-8 system we have for uninsured motorists is only New Hampshire. And I believe this would all then be an extension of that, only New Hampshire. And the insurance companies do have some difficulty remembering this law because we are the only state that has it, and we're only 0.4% of the market. And the last piece is that we are concerned about unintended consequences. People have brought up to me the issue of how people are going to address their deductibles going forward. If they know there's a potential of them getting waived, maybe they'll increase them. There's an issue of maybe people start arguing more strenuously that the other party is solely at fault. Again, we have the UM part is hard enough to put out there for the insurance companies as it is. To make it even more difficult would probably not be good for the New Hampshire consumer. So I think for those reasons, one, it was put in place for uninsured motorist coverage so you can protect yourself. Two, the liability system works fine in New Hampshire. We don't receive any complaints on this. And third, we do have a concern about unintended consequences if this were put in place. So for those reasons, the department is opposed to the bill. And I'm happy to answer any questions.
Thank you. Any questions from the committee? Seeing none, thank you very much.
Thank you.
Mark Jenkins.
Good morning, Senator French, members of the committee. My name is Mark Jenkins. I live in Manchester. I've been an insurance agent for just over 35 years now. At the moment, I am the head of the commercial claims department at an insurance agency in Alton. And this is something that we have seen quite a bit. I know I have written testimony here, and I've been listening to a couple of other people who have spoken earlier. One of the largest issues that we see when we deal with claims, specifically automobile claims, is the problem where people get into accidents. And I'll use an example of one of our clients who has a disabled daughter and they have a disability van that they drive around in. A few weeks ago, they were pushed off the road by another vehicle, ended up going down in a ditch, and now their van is not quite totaled, but it will need a lot of work. The other driver took off, was subsequently found, and cited for leaving the scene of the accident, but through their failure to cooperate with the insurance companies, our client now has to wait several months through subrogation to try to get their $1,000 deductible back. This is not something that they have. All of the money goes into the medical bills for their daughter. So the van rather, will sit there until they can come up with the extra $1,000 to do that, to get it out after the insurance companies have paid for it. It happens quite frequently with older clients that we have who get into fender benders, being rear-ended at a stoplight. Now they have to come up with their $500 or $1,000 deductible or whatever it is to get their car out of the shop and hope that through subrogation they will get the money back. And this can be something that takes a couple of months for them to recoup. There has been some discussion about uninsured motorists if you get into an accident with someone who doesn't have insurance. And we already know that that is part of it. If the person is uninsured and you can prove it, then that's going to, you automatically will have that waived and it won't come out of your pocket, because seemingly that would be unfair. However, if we know who did it and the choice is there to go to the other insurance company, what we see quite frequently is that the person who is at fault for the accident will not cooperate with the other company. So trying to come up with the actual percentage of fault, who is actually at fault. It comes up to one person's word against the other, and they're going to have to talk to their client before they make any payments whatsoever. So we have seen it where a client will go to another company, Progressive, Travelers, whoever it is, and it will take several months just to get the claim going because they're not cooperating, thinking that they would be able to get around that, if they don't talk to me, then I'm not, at fault for the whole thing and it's going to go away. So what the bill is trying to do is to take away that burden that a lot of people cannot carry to get their car back when they've had an accident that is no fault of their own. And if we know who did it, then actuarially for the minor increase in your annual premium that you would be charged, actuarially that will be quite minor in the scheme of things, in your annual premium. And, for a $5 or a $10 extra fee, the insurance company is betting on a $500 or $1,000 deductible and getting as much money as they can back. So what we're trying to do is to minimize the burden on families who don't have the funds. And through no fault of their own, now they're being penalized with having to come up with these monies. But I hope that is something that you would consider. And I thank you for your time. I'm open for any questions you might have.
Thank you for your testimony today. Any questions? Senator Gannon?
I wish I had thought this out more before, so I apologize if my questions were poorly worded. Does this really only work if one side's totally at fault, right? This isn't going to be as good if, most of the time, aren't I going to deny if I hit you or you hit me? How many times do accidents occur where it's 100% clear that one side is at fault?
At least 3/4 of the time, the ones that we deal with anyway, they're typically someone running a red light, someone not paying attention and hitting someone from behind, someone backing into somebody else in a parking lot, things of that nature.
Oh, okay, I didn't, 3/4, well, okay, thank you.
Anyone else? Seeing none, thank you very much.
Thank you.
We have Mike McLaughlin, who is opposed and not looking to speak. George Russo, opposed and wishing to speak. George?
Thank you, Mr. Chairman, members of the committee. My name is George Russo. It's been a while since I've had the pleasure of appearing before this committee. I can't tell you how great it is to be here in person after so long.
We are thrilled to have you back.
I appreciate that as well. So I do want to mention, because it's been so long, a little bit more about who my clients are and what our interest is in this legislation. I'm a lawyer with Orr & Reno, and I'm also a chartered property casualty underwriter. I'm here today representing two insurance company associations. One is a local, or was started as a local domestic association way back in 1977. I was involved in their formation back then, and it was companies that were incorporated in New Hampshire. It's since grown to include other companies. In addition to the New Hampshire Association of Domestic Insurance Companies, I'm here representing the American Property Casualty Insurance Association, which is national association, and between the two of these clients, we represent most of the insurance companies that write automobile insurance in New Hampshire. Typically, our clients oppose bills that are mandates. We think they're harmful and they're expensive to enforce, and in this case, unnecessary. And we oppose bills that tend to increase prices, the cost of insurance. And this bill would do that. Mr. Jenkins himself suggests that there would be a minor increase in a premium, but that people would happily pay it. I agree, it's not, my guess is it wouldn't be a substantial increase, but there would be an increase in, likely increase in premium if this bill were to pass. And as you know, this is a very competitive area, automobile insurance is, and people, when they shop for automobile insurance, are particularly concerned about the cost of insurance. And they have many options when they buy insurance. The only coverage they're required to buy is liability insurance. And even there, they have options to buy it from $25,000 per person liability up to $250,000 in increments per person. And then above that, typically to cover themselves if they have excess insurance or an umbrella insurance policy. And so cost drives what an insured would pick for liability limits. We're talking here about collision limits. There's no requirement that anyone buy collision coverage at all. And when I've had old cars, I think many people will do that, will say, well, I'll self-insure it rather than pay the premium for collision. If someone chooses to buy collision coverage, there's a range of options. They can have a deductible of $50, $100, $250, up to $1,000, and I think higher than that. And that's the choice of the insurance buyer. Most commonly, it's probably about $250, maybe $500 is what people tend to pick. So the scope of this problem is a $250 problem or a $500 problem for a person who would be delayed for a couple of months before being able to recoup that amount of money. And I have no doubt that the instances that have been described are sincere and have happened, but these anecdotes, I think, are not representative of the environment generally in New Hampshire for this situation. And I think Mr. Fox testified that they have not had complaints from the insurance to the insurance department from people concerning the deductible. And I've checked with a number of my client companies, and they're not aware of any problem either. So people have choice today, and this mandate takes away the choice with respect to the waiver of the collision deductible. So we don't think that's a necessary change. As has been stated, this is the only, there's no state in the country that has a waiver of deductible in this situation. And just to be clear, the fact that we have no mandatory auto requirement and the fact that the current law provides for a waiver of the deductible or the collision deductible when the uninsured motorist is at fault has nothing to do with this bill other than it's a sort of a creative extension of what goes on in with respect to accidents involving at-fault uninsured motorists. That's something that, as Mr. Fox said, New Hampshire put into the law, recognizing that we do not require insurance and that if people have an accident with an uninsured motorist, they're probably not going to get their deductible back because the uninsured motorist isn't going to have the money to pay. It's not worth pursuing. But that's not the case where the motorist is insured and is at fault. It's going to be pretty close to 100% of the time, if not 100% of the time, that by definition the driver is going to recover from the at-fault motorist if they're insured. Happy to answer any questions.
Great, thank you. Any questions? Seeing none, we're all set.
Thank you very much.
Thank you. I don't have anyone else on the sheet. Is there anyone here wishing to speak on Senate Bill 331? Seeing none, I'll close the hearing on Senate Bill 331. And, is this yours? Oh, 17, okay. And I'll open the hearing on Senate Bill 347 with Senator Daniels to introduce it.
Morning, Mr. Chairman, members of the committee.
Good morning.
For the record, my name is Gary Daniels. I'm a state senator from District 11, encompassing the towns of Amherst, Merrimack, Milford, and Wilton. I'm also the prime sponsor of Senate Bill 347, which is relative to discrimination in the workplace. This bill prohibits an employer from inquiring about an employee's protected health information as a requirement for initial and continued employment, thereby preventing and curtailing the discrimination that is currently taking place in our state to the detriment of our constituents. This issue is one that we really have not encountered in the past, up until the past couple of years, but the door to discrimination in the workplace has been opened by employers asking their employees for their personal health information. That is, whether or not they have been vaccinated, and if the answer is in the negative, issuing an ultimatum to the employee to get vaccinated or be terminated. While vaccination status is the primary driver of this discrimination, I'm told by Senate counsel that employers are not restricted from asking for protected health information, including whether or not a person is diabetic, if they have high blood pressure, if a woman has had an abortion, or if the person has been vaccinated or had a booster or two, or any other number of probing questions that may have nothing to do with the individual's ability to do the job in question. Senate Bill 347 simply states that an employer cannot ask for protected health information if it is not directly related to the individual's ability to do the job. If a person is applying for a job in a stockroom or delivering furniture, then the employer can legitimately ask the person if they could lift a certain weight. Likewise, an applicant for a linesman position could be asked if they could walk a certain distance. But asking for personal health information unrelated to the person's ability to do the job is just plain wrong and intrusive. The situation we currently have in state is that people are being terminated for no reason other than that they have chosen, for whatever reason, to pursue a personal health care path that is different than that desired for them by another person who has not the full knowledge of the individual's personal health information. This includes individuals who have worked successfully at companies for well over 20 years, as well as the state's medical providers, the very ones who put their lives on the line to treat us during the ongoing pandemic. With a few exceptions, New Hampshire employers are free to self-regulate their work environments. This bill would not prevent an employer from requiring its employees to wear masks. The bill focuses on the discrimination that is now taking place because some employers are using protected health information unrelated to the job as a basis for termination. The New Hampshire legislature has been diligent in ensuring that New Hampshire workers enjoy an environment that is free from discrimination. Senate Bill 347 will continue that tradition and eliminate one factor that is contributing to worker shortage in the state. I want to end with this. Article 2B of our Constitution states that an individual's right to live free from government intrusion in private or personal information is natural, essential, and inherent. If it is not okay for the government to be asking for this information, I think we need to ask ourselves why it would be okay for an employer to seek that same information. So I ask the committee to look upon Senate Bill 347 as ought to pass, and I'd be glad to take any questions. Thank you, Mr. Chairman.
Thank you, Senator. Any questions? Senator Gannon?
Thank you. Thank you, Senator Daniels. I've been struggling with this for a while, so I'm glad you're here today, because maybe you can help me and maybe that'll help someone else. So liberty interests, rights of, I understand where you're coming from, the rights of the employee. What about, I start a small business, I have 7 or 8 people. And we don't even have, we'll just take the public out, we don't deal with the public. But my wife will just say she has a pre-existing condition, and I'm a nervous Nelly that she's gonna get sick, she's approaching 60, she's maybe got a couple of conditions. So I'm really concerned having people in my little office with 5 or plus people, we'll say, and I'm very scared that you're taking my rights to protect myself, my health, and my families. And so I see a difference where you were saying, if we ask them if they could walk a certain distance, that doesn't have anything to do with them coming into my office, but the fact that they may come, and whether or not it's whether or not really there's a danger from the COVID or not, if I'm fearful and it's my business, don't I have a right to not have you in there if I'm fearful of my own liberty interests? So do you see where I have a problem that maybe there's an employer right and an employee right, and they're coming into conflict in here? So can you help me solve that problem?
Sure. Thank you for the question. I think as an employer, in the situation that you're talking about, you haven't described what the issue is, but I think that you probably would be fearful of anyone walking in the door. I mean, if you're concerned about your employees carrying some sort of disease that's going to affect your family member, then why wouldn't you also be concerned about every customer that walks through the door? Secondly, if we're talking specifically about COVID, it doesn't seem to matter whether you're vaccinated, boosted, unvaccinated, you are subject to catching and transmitting the disease. I think we know by now that the vaccination has really done nothing except to somewhat ensure that you're not going to end up in the hospital. So it doesn't cure the disease or prevent the disease as we look upon other things like smallpox.
And so if I may ask.
Go right ahead.
Thank you, sir. So we'll take out, we'll say I'm a stock trading little business. I have these 5 traders we just work alone. We don't have public coming in. So we'll take that part of the equation out. So it's just me, 5 other people sitting here, and one of them says, I just don't want to get vaccinated. And I'm still concerned that my interest, it's my shop. Haven't we always been that way in New Hampshire? It's my business, my shop. I should be able to run it the way I want to. Isn't that what we usually would argue?
We do, but let me say that in your question, you had the employee say, I just don't want to get vaccinated. This bill would prohibit the employer from asking if the person was vaccinated. Secondly, while we do allow employers to run their environments, as I mentioned, self-regulated, RSA 275-37 mentions 3 things in discrimination that has to do with smoking, flexibility in the workplace, and the third one has to do with asking about criminal records. We, the legislature, have decided that those things fall under discrimination, and that they should not be asked for or persons retaliated against because of an answer that they may give. So what this bill is doing would be adding in a fourth one under Discrimination Act that says that you can't ask for your personal information. And then I would finally end with again, asking the question, if the government is prohibited from seeking this personal health information through our Constitution, why should it be okay for an employer to do otherwise?
Thank you, Senator.
Anyone else? Seeing none, thank you very much,
Thank
Senator. And we'll hear from my friend, Rep. Timothy Horrigan. Tim has left the room. Peter McKenna for Labor, wishing to speak.
Good morning. Thank you to Mr. Chairman and to the committee. My name is Peter McKenna. I'm an attorney with the New Hampshire Department of Labor. The department does not take a position on this bill, but there were a couple of issues that the department wanted to bring to the attention of the committee while the bill was discussed, and I wanted to make myself available for any questions if there were any. But there are two things that we really noticed. One is the definition of protected health information. That definition is pulled from the federal rules, 45 CFR 160.103. Under that provision, that protected health information only covers written information. It only covers information that is transmitted or maintained in electronic media, or that is transmitted or maintained in some other form. And so under that definition, there may be information that a person has that is not written down. So first, the employer wouldn't know if they're asking about protected health information. One example that we just heard is whether a person is vaccinated. But it's not clear that that would be in any written form. It may be that a person is unvaccinated, but that is not written in any medical document, and they don't have a card showing that they're unvaccinated. And so it's possible that under the definition that's given, that would not qualify as protected health information because it's not written down. And because the definition turns on whether it's written down or not, the employer, as again, might not know if they're asking about protected health information. They don't know what's written down in a person's medical file or someplace else. The other thing we wanted to bring to the attention, and this may be covered by paragraph 2 of section 1, but that is there are situations where an employer would need to ask about protected health information, and it's unclear if that would fit the carve-out for being relevant to an employee's ability to perform his or her job duties. For accommodations under the ADA or for accommodations for family medical leave, an employee necessarily needs to provide some information. An employee might request an accommodation for a medical condition, but if the employer would be prohibited from asking about it, it would really be a situation where the employee comes up and says, I need an accommodation for this, but I need an accommodation in this way, but you can't really ask me why I need that accommodation. Now, it may be that section or paragraph 2 of section 1 would cover that, but it's unclear that every accommodation, a small one, for example, would be relevant to their ability to perform their duties, but there are some situations where an employer might not be able to ask about it. The same for family or medical leave. I need to take a few days off, but the employer might not be allowed to ask why it is, depending on how section 2 is read. So those were just the two issues that the department wanted to bring to the attention of the committee. Again, we take no position on this bill, and I'm happy to answer any questions that the committee might have.
Thank you very much. Any questions? Seeing none, thank you for your testimony.
Thank you.
Paula Minahan, opposed, looking to speak. Good morning, Paula.
Good morning. Can you hear me? Good morning, Mr. Chairman, members of the committee. For the record, my name is Paula Minahan, Senior Vice President, State Government Relations for the New Hampshire Hospital Association, representing all our hospitals. We have major concerns with this bill as drafted. As you know, the bill before you would prohibit an employer from inquiring either verbally or in writing about an employee's protected health information as a requirement for initial or continued employment. The language as drafted is confusing and seems to be contradictory. We read the bill as trying to equate protected health information as defined by the federal HIPAA law with something an employer cannot request or maintain of its employees. This is an incorrect use of HIPAA, as employers are not subject to HIPAA in most instances. And I cited the CFR, the federal statute that shows protected health information and the excludes individually identifiable health information and item Roman small 3 in employment records held by a covered entity in its role as an employer. The exclusion allows healthcare providers, insurers, and healthcare data clearinghouses known as covered entities to maintain employment records separate and apart from HIPAA rules. In addition, I attached a FAQ from the federal HHS.gov website. HIPAA does not apply to any employer, healthcare or otherwise, in their role of managing employees. Only healthcare providers, insurers, and healthcare data clearinghouses are covered entities that are subject to HIPAA, not all employers. In addition, HIPAA is narrow in that it prevents healthcare providers, insurers, and healthcare data clearinghouses from sharing a patient's medical records without their explicit consent. The HIPAA has nothing to do with asking an individual about their health status. In fact, HIPAA would not be violated if an employer requested their employee's health status, including vaccination status, because HIPAA does not protect medical information that an employee shares about themselves. This bill's attempt at intertwining all employers as being covered by HIPAA's definition of protected health information is an appropriate application of the federal law. Thank you for the opportunity to provide my comments.
Thank you very much. Any questions? Senator Bradley.
Good morning, Paula.
Good morning.
So when we passed House Bill 220 last year, we made it very clear, I think, that the government could not mandate vaccination. But we left it up to individual employers and their terms of employment as to whether the employer would request a vaccination. So how would this bill and that bill be consistent? Would they be?
I thank you for the question, Senator Bradley. I believe that there would be some inconsistency. But most confusing to us is kind of referencing HIPAA. It's not in this context. I don't believe it's appropriate because, again, employers can request information from their employees, and it is not subject to HIPAA. So that's where I struggle. But yes, we do believe, obviously, that employers have the right to require, if determined appropriate for them, for their employees and their patients, in our case for the hospitals or guests or clients, that they require vaccinations, we believe is appropriate. I also wanted to just go on record as stating for today, as of yesterday, we have 409 hospitalized patients struggling with COVID. 147 are recovering. What that means is they no longer have the diagnosis of COVID, but they are so sick, they are typically in the ICU and remain there for many weeks, days and weeks, depending on how sick they are. But they are not counted in the COVID number, so we are counting them. 16 right now are waiting in the emergency room to get into the hospital because there's no space, unfortunately. And we are on record as supporting. We believe COVID vaccine has and does prevent serious illness and hospitalization and death. So we strongly support the continuation of requiring COVID vaccines in the employer setting.
I think there was some question in another hearing last week that you testified at. So
as I recall, there were percentages given of the number of vaccinated people that were in the hospital, unvaccinated people. And maybe you could go through those, but the thing that sort of stuck in my mind was the very high percentage of people in the ICU that were unvaccinated. So maybe for the committee, you could go.
Yes, unfortunately, I don't have those current numbers. I will get them for you, and I will email them to the committee. Last week, I believe it was roughly 43% of those in the hospital right now are unvaccinated. About 17%, we do not know their status. I think it was 23 or 26% are fully vaccinated, and whatever the balance is they're partially vaccinated, meaning they have 1, 2, but not necessarily their booster. But what Senator Bradley is referencing is the vast majority, unfortunately, of individuals in the ICU struggling on ventilators, very sick, intubated, and are there for a long time. The vast majority, over 70%, are unvaccinated. And that is the concern, that they get very, very sick.
Thank you.
You're welcome.
Can I just ask one more question?
You can ask as many as you wish. Thank you.
So as I recall, the highest number of COVID patients that the 26 hospitals had in their facilities was about 470, I think. And so you're down 15% at this point. And where do you see that trend line going now that we're past the holidays?
I will defer that answer, and I will get you more information, because I think I think you're right, the trend line is important. What we didn't collect until recently are the recovered. So I think that was underreporting those that were in the hospital recovering from. I think it's after, and I'm going to need to verify this, it's either 2 weeks or 21 days after you're recovered from COVID. But if you're still in the hospital, we count those as recovering, and those are right now 147. The hospitalizations of 409, I believe you're right, Senator, that number has gone down, but the recovered is a new statistic that we're starting to collect. And the ones in the emergency room are not admitted yet. They're waiting to be admitted, so we decided we needed to count those too. And the way that we collect, the hospitals provide this information daily, and we have a daily huddle with the hospitals working to try to ensure that anyone that needs to be transferred typically to an ICU and they're not able to. I mean, it happened just yesterday that there was one up in the North Country, needed an ICU bed, and a hospital in the Seacoast said, I have one, and they immediately got that person transferred. So that's what we're working on daily to try to ensure people are getting admitted and cared for.
Sorry, Mr. Chairman. Now a comment. It's been a long haul for the hospitals. I don't think we can say enough how hard folks like Paula have worked and all the frontline healthcare workers in our hospitals.
Thank you.
Thank you.
I will pass that on to our healthcare workers. I agree.
All set?
Oh, thank you, Senator.
Thank you very
Thank
much,
you.
Paula. Curtis Berry is opposed and not wishing to speak. Match Grays, opposed, looking to speak.
Thank you, Senator. Nate Grays for the New Hampshire Municipal Association. I did submit written testimony via email yesterday, so hopefully you have been able to see that. My comments this morning are basically going to reflect that. I certainly would thank Senator Daniels for clarifying the bill. When we first read it, it was a bit confusing how paragraph 2 and paragraph 1 related in terms of what information an employer could actually obtain. But we do remain concerned that there are instances where an employer will be required to make some sort of reasonable accommodation under the labor laws in order to accommodate someone with either a disability or some sort of condition that they might not know about, and it's unclear under this statute or under this bill when that would be available. So a good, easy example is someone who is pregnant. The employer might have a notification policy. So, you know, in the context of a manufacturing facility, that's pretty easy to figure out. You might have a situation where they're working with some sort of chemicals that exposure to a pregnant person would be ill-advised, and they would provide them different job duties. The same might occur with municipalities, especially with first responders who are obviously responding to different and dangerous situations, whether fire or police, and they might be responding to, for example, a fire at that facility, or you know, some sort of burglary alarm or something like that. And the employer would want to know and be able to make some sort of accommodation to make sure they're not sending their employees into harm's way. And it's not clear from this bill when they could obtain that information, and we are concerned that the employees may become harmed. Thank you, and I'm happy to take questions.
Thank you. Any questions? Seeing none, thank you very much. That's it for our list of people requesting to speak. Anyone else here wishing to speak on Senate Bill 347?
I have a question of Curtis Berry.
Hold on just a second.
Good morning.
Good morning. Will you take a question from Senator
Certainly.
Bradley?
And just for clarity, I signed in opposition on behalf of the New Hampshire Retail Association.
That was my first question. So my second question then would be, could you describe for the committee, you know, why the Retail Association and your members would be opposed to
Sure.
this?
And I think it comes in two parts. The Retail Association very recently adopted a formal policy, sort of a blanket statement on a lot of these related bills, both in the House and the Senate. But to sum it up, and this is something that I relayed to the study committee that Representative Lang was chairing over the summer. The Retail Association opposes mandates from the government in this area. At the same time, the Retail Association believes that employers, including retailers, are responsible for the health and safety of their workplace on behalf of their employees and their customers, and should have the ability to make this decision, these types of decisions, on behalf of those folks that they serve and employ in the overall health and safety of their workplace. The second point is, it goes to the exception, I think, that's in this bill, and I appreciate the sponsors' attempt at recognizing that some circumstances require certain questions. I'm not sure, I wouldn't be able to tell whether this exception covers this particular circumstance, but back in the spring, I testified in the House on a non-germane amendment, a public hearing, and many retailers responded, and that proposal would have prohibited asking the question whether somebody's vaccinated or not. And many retailers responded with certain situations. I need to make a delivery into a nursing home. We need to deliver furniture into a home of individual who is at particular risk. And the inability to even ask the question if an employee is vaccinated or not in order to schedule folks for certain tasks makes their life a little bit more difficult. So I hope that answers your question and sums it up.
Go ahead, Senator.
So that non-germane amendment, was that on Senate Bill 155?
That sounds right. Without checking, I'd have to ask. It was in the House Executive Departments and Administration Committee.
Further question? So the same question I asked Ms. Minahan, the consistency with Senate Bill 220 and this bill, do you care to comment on that? Again, Senate Bill, or House Bill 220 indicated that the government in its functions could not mandate a vaccine, but left it to the discretion of individual employers. That was where we ended up. So could you comment about the consistency of the two pieces?
Sure. The Retail Association took no position on that bill in any stage of its progress through the legislature. I think that bill from last year in what was enacted is consistent with what the retail position is, the Retail Association's position is. This bill seems to prohibit the employer from making a decision based upon what they think is best for the health and safety of their workplace.
Thank you, Mr. Chairman.
Thank you. Anyone else? Seeing none, thank you,
Thank you.
Curtis. Senator Daniels, did you wish to speak again?
Thank you, Mr. Chairman. I just wanted to address one of the concerns of the Department of Labor, because they indicated that the federal statute only talked about written. And I just want to read from you 45 CFR Section 160.103. Protected health information means individually identified health information except as provided in paragraph 2 of this definition, which has to do with educational records. Then transmitted by and so it has to do with identifiable health information transmitted by electronic media, maintained in electronic media, or transmitted or maintained in any other form or medium. I would contend that that means that could be verbal as well. Thank you.
Thank you. And anyone else wishing to speak on Senate Bill 347? Then I'll close the hearing. And we'll take up Senate Bill 354, Senator Susie. Pardon me? Oh, yeah. Yeah, thanks for bossing me around. Whenever you're ready, Senator.
Always concerned about the rights of employees, Mr. Chairman.
I appreciate that, and I too have that same concern. I just forget it.
Thank you, Mr. Chairman, members of the committee. For the record, I'm Donna Susi, representing Senate District 18, which is comprised of Manchester's wards 5 through 9 and the town of Litchfield. Senate Bill 354 comes to you as a request of the Insurance Department to make several changes to their licensing statutes. These changes include modifying the adjuster law to define good cause for license non-issuance, codifying the practice that license renewal fees are non-refundable, clarifying that banks don't need a license to sell credit, life, and accident insurance to resolve an existing conflict in statutory language, and to require the producer for a business that sells insurance to actually hold a license for the lines of insurance that are being sold. My understanding is that the industry is in favor of these changes, and I believe Josh Hilliard is here from the department who might answer any of your more specific questions. With that, I'd be happy to answer any questions, but would defer the technical ones to the department at this time.
Thank you. Any questions? Seeing none, thank you, Senator.
Thank you.
Josh Hilliard from the department.
Good morning, Mr. Chairman, members of the committee. Thank you for your time.
Good morning.
My name is Josh Hilliard. I'm the Compliance and Enforcement Counsel of the New Hampshire Insurance Department, and I'm here to speak on behalf of the department in favor of this bill. As Senator Susi described, there's 4 changes in this bill. I'd like to walk you through them very quickly. The first is to 402B12, which would change that to be in accordance with 402J. 402B12 is as to the adjusters in our state. 402J is as to the licensed producers, insurance agents. And this would change 402B12 to have the same language that 402J does as to the grounds for bringing actions, administrative actions, against those persons. In essence, it defines good cause as the same reasons under 402J for which we bring administrative actions against licensees. The second change to 400A29, which as Senator Susi described, codifies the practice which has been that application or renewal fees are non-refundable. Right now, under statute, application fees are, but renewal fees are not, and that would just change that. The third change is because there's a conflict in our law. 406C indicates that financial institutions, including banks and credit unions, are not required to acquire a license in order to sell credit life, credit disability insurance, except 408A9 indicates that anyone must acquire, including entities, acquire a license in order to sell those lines of insurance. This would indicate and make that change to the statute that those financial institutions do not need to get a license to sell the credit life or credit disability insurance. And lastly, the fourth change is to the requirement as to having a designated responsible licensed person for an entity. That's the insurance producer that's responsible for making sure the entity is in compliance with our laws. Right now, there's no requirement under the law that that person be licensed in the same lines that the entity is. So for instance, you could have a business entity that's selling life insurance, but they could have a designated responsible licensed person that may only be licensed in property and casualty. But that person's responsible for the entity's compliance with the laws. And there's a mismatch there. So we'd like to see it in statute that the person or persons responsible for that entity's compliance with the law have the licensure for the lines which that license is selling. I'm happy to answer any questions you may have.
Thank you. Any questions? Seeing none, thank you very much.
Thank you.
It appears the entire New Hampshire Insurance Department is in favor of this bill, including Marty Mobley and Joan LaCourse. Not wishing to speak, and George Russos is in support and not interested in speaking. Anyone else here interested in speaking on Senate Bill 354? Seeing none, I'll close the hearing. We have a motion for executive session by Senator Bradley, seconded by Senator Susi. What do you think? Start at the beginning? Because it's right in our minds. Go ahead. We have a motion of ought to pass by Senator Bradley, seconded by Senator Kavanagh. All in favor, say aye. Aye. Opposed? Motion for consent by Bradley, seconded by Susi. All in favor? Aye. Opposed? And, yeah, would you take it up, Tom? Thanks. And we'll take up Senate Bill, my favorite of the day. If I can find it here. Oh, yeah, Senate Bill 207. We have a motion of ought to pass by Senator Bradley, seconded by Senator Susi. All in favor? Aye. Opposed? We've got consent by Susi, seconded by Bradley. All in favor? Aye. Opposed? I'll take that one out. We have a motion of ought to pass on Senate Bill 208. All in favor? Aye. Opposed? Consent by Susi, seconded by Bradley. In favor? Aye. Opposed? And Senator Kavanagh, do you want to take that one out? It wasn't my favorite, but
A little more weedy.
yeah. Yes. Yeah, that's what I was thinking. Sure, yep. That about do it? Yeah. Can I have a motion come out of executive session? By Bradley, seconded by Susie, all in favor? Aye. And a motion to adjourn. All in favor? Aye. Close this committee, thank you very much.
Smooth. Nope.
No.
Just one's next week, right?
Correct.
Oh, I didn't know that. We don't? Next Thursday? Oh, good.
We're meeting next Thursday.
Yeah.
Here.
Yeah. This committee's meeting. That way we can push through.
Yes, slips, I just have to sign it out, so yeah.
Absolutely, yeah. Wednesday,
Not here.
I think Gary's gonna be thrilled with me.
And I didn't say anything, I let it go. But it's such an inconsistency for every other piece of legislation.
I
No, our
understand.
business owners decide.
I understand.
We can't do anything because of, and now all of a sudden it's like, nope.
I know, that's why it's easier for me to follow that.
You gotta understand, we don't care about consistency.
That's the hard problem, right? That's all I'm saying.
We like patchwork, thoughts and process.
It's just very forthright.
See you guys soon.
See you guys.
Yeah, so I'll see you this afternoon, sir.
Yes.
And the beginning, Jen, is just gonna be full of few bills, and now that we've had enough days, it's like, I need another binder.
It's like, I don't have this. Aaron does a great job.
We're looking out for you, Aaron, because you look out for us.
Thank you, Aaron.
You're welcome. Have a good day, Senator.
I will.
Is judiciary going to be long today, you think?
No, tomorrow's the day that'll go on into the night.
Aaron, just so you know, I think the mics are still on. Someone said it was still streaming.
Yeah,
Okay,
so-
just so you know, I didn't want to